State will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right, so before I continue with the jury charge, I just want to thank all of you for your continued attention to the proceedings, as well as your continued attention to arrive here timely each and every day. So I know it's been quite some time. You've been very diligent about getting here and being attentive to the proceedings. So I appreciate that very much. So I wanted to thank you for that. At this time, when we adjourned on Thursday, we were going through the court's instructions as to the law that you are to apply to this case. I am going to pick up where the court left off, and that is at count 4, assault in the second degree, intentional, Connecticut General Statute, section 53A, 68-2. The state charges the defendant at count 4 with assault in the second degree, charging that in the county of Fairfield in the city of Shelton on or about the 14th day of May, 2022, at or near 43 Laurel Glen Drive in said city, the defendant, with intent to cause physical injury to one Faison Teal, did cause physical injury to the said Faison Teal with a dangerous instrument, to wit, a knife, in violation of section 53A 68-2 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he causes such injury to such person by means of a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. We'll refer to the court's previous instruction on specific intent at 15. Physical injury is defined as an impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious, it may be minor. Element 2, caused physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. We refer to the court's previous instruction on proximate cause at 14. You must find it proved beyond a reasonable doubt that Faison Teal was injured as a result of the actions of the defendant. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to that person or some other person. Element 3, with a dangerous instrument. The third element is that the defendant caused the injury by means of a dangerous instrument other than by means of a discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation and even though harmless under normal use may be found by you to be a dangerous instrument if, under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person, 2, the defendant did cause physical injury to Faison Teal, and 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of the crime of assault in the second degree intentional at count 4, and you shall then next consider the lesser included offense of assault in the second degree reckless. You'll proceed to the court's instruction on lesser included offenses to assault in the second degree intentional below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in second degree intentional, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree intentional in violation of Connecticut General Statute, Section 53A 68-2 at count 4. This will end your deliberations at count 4. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree intentional at count 4, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 4. Lesser included offenses to assault in the second degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses to assault in the second degree. If and only if you have unanimously found the state has not proved beyond a reasonable doubt all of the elements of the crime of assault in the second degree intentional, and therefore that the defendant is not guilty of assault in the second degree intentional at count 4. The defendant at count 4, the substitute information, is specifically charged with the crime of assault in the second degree intentional. The offense of assault in the second degree intentional under under our penal code is such that it may include the elements of the crime of assault in the second degree reckless. Similar to my previous instructions on lesser included offenses, this brings into play the rule of law known as lesser included offenses. You will consider lesser included offenses to assault in the second degree intentional in the order and under the circumstances as provided herein. The fact that I am instructing you on a lesser included offense to assault in the second degree intentional as to count 4 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the second degree intentional or is guilty of the lesser included offense. If and only if you unanimously found that the state did not prove beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, and that the defendant therefore is not guilty of assault in the second degree intentional at count 4, shall you consider the lesser included offense of assault in the second degree reckless directly below at subsection A. A. Assault in the second degree reckless, section 53A 68-3. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when he recklessly causes serious physical injury to another person by means of a deadly weapon or a dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, recklessness. The first element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk that such result will occur or that such circumstances exist. Refer to the court's previous instruction, recklessness, at 16. Element 2, cause serious physical injury. The second element is that the defendant caused serious physical injury. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction of proximate cause at 14. You must find it proved beyond a reasonable doubt that Faison Teal was seriously physically injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or a serious loss of impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element is that the defendant used a dangerous instrument in causing serious physical injury to another. Dangerous instrument means any instrument, article, or substance which under the circumstances in which it is used or attempted or threatened to be used is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation, and even though harmless under normal use, may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1. The defendant acted recklessly. 2. The defendant caused serious physical injury, 2. Phase on teal, and 3. The defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 4. This will end your deliberations on count 4. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, you shall next consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statutes, Section 53A, 60A3 at count 4. This will end your deliberations on count 4. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then, on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 4, even though you have found the elements of the crime proven beyond a reasonable doubt. This will end your deliberations on count 4. 22. Self-defense, defense of others. The defendant has offered evidence in this case that he acted in self-defense and or the defense of others. Self-defense and defense of others are two separate but related defenses. Although the court is instructing you on both defenses under this section, the defendant is entitled to and must be given by you a separate and independent determination as to each defense under each count. After you have considered all the evidence in this case, if you find that the state has proved beyond a reasonable doubt each and every element of a crime to which self-defense, defense of others may apply, you must go on to consider whether or not the defendant acted in self-defense. In this case, self-defense and the defense of others applies to all crimes charged in the substitute information under each of the 4 counts, along with the lesser included offenses to each of those crimes at each count. In other words, self-defense and the defense of others applies to all offenses submitted to you for deliberations. The statute defining self-defense, defense of others reads in pertinent part as follows. A person is justified in using reasonable physical force upon another person to defend himself, a third person, from what he reasonably believes to be the use or imminent use of physical force. And he may use such degree of force which he reasonably believes to be necessary for such purpose, except that deadly physical force may not be used unless the actor reasonably believes that such other person is using or about to use deadly physical force or inflicting or about to inflict great bodily harm. The determination of whether a defendant reasonably believes physical force to be necessary to defend himself, someone else, from what he reasonably believes to be the use or imminent use of physical force by another individual is 1. Whether the defendant actually believed that the other person was using or about to use physical force or deadly physical force against him, a third person, and 2, whether a reasonable person in the defendant's position, knowing what the defendant knew and being in the same circumstances, would have had those same beliefs. Whether the defendant's belief was reasonable is a question of fact for you to determine based on all the evidence presented. The acts of the other individual, James McGrath at count 1, Ryan Hines at count 2, Thomas Connery Jr. at count 3, and Faison Teal at count 4, leading to the defendant's use of defensive physical force need not be an actual threat or assault. The test is not what the other person actually intended, but what the other person's acts reasonably caused the defendant to believe was the other person's intention. The state's burden. When evidence of self-defense, the defense of others, is introduced at trial, the state, in order to obtain a conviction, must prove beyond a reasonable doubt both the elements of the crimes charged and that the defendant did not act in self-defense or defense of others. If the state fails to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, unless the state proves beyond a reasonable doubt a statutory disqualification, as discussed further below in this section 22 at statutory disqualifications to self-defense, defense of others, and statutory disqualification to the use of deadly physical force, you must find the defendant not guilty, despite the fact that you have found the elements of the charged crime proved beyond a reasonable doubt. The defendant has no burden of proof whatsoever with respect to this defense. Deadly and non-deadly physical force. The law distinguishes non-deadly physical force from deadly physical force. Deadly physical force is justified only when a person reasonably believes that such force is necessary for the defense of oneself or others against the use of imminent use of deadly physical force or infliction or imminent infliction of great bodily harm. Deadly physical force is physical force which can reasonably be expected to cause death or serious physical injury. Physical injury is an impairment of physical condition or pain. Serious physical injury is a physical injury that creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Imminent means that the person is about to use physical force or deadly physical force at that time and not at some unspecified future time. The physical force used by the defendant need not actually have caused a death or a serious physical injury in order to be considered deadly physical force, nor need it have been expected or intended by the defendant to result in such serious consequences. Instead, what determines whether the defendant used deadly physical force is whether the force actually used by the defendant could reasonably have been expected to cause death or serious physical injury. It is up to you to determine, after considering all the evidence, whether the defendant used deadly physical force or non-deadly physical force against James McGrath at count 1, Ryan Hines at count 2, Thomas Connery Jr. at count 3, and Faison Teal at count 4. If the state claims that the defendant used deadly physical force, the state must prove that beyond a reasonable doubt. In addition, the state may prove that the defendant's use of force was not justified if it can prove beyond a reasonable doubt that while the defendant may have believed that he needed to use such force, his belief was unreasonable in light of all the circumstances known to him at the moment. Whether the defendant's belief in the need to use such force was reasonable is a question of fact for you to determine. However, a person must use no more force than he reasonably believes is necessary for such purpose. Statutory disqualifications to self-defense and defense of others. In addition, the state can defeat the defendant's claim of self-defense or defense of others by proving beyond a reasonable doubt one of the statutory disqualifications to self-defense, defense of others. The statute defining self-defense, defense of others describes certain circumstances in which a person is not justified in using any degree of physical force in self-defense, defense of others against another. These circumstances include provocation and initial aggressor, as more fully instructed below at subsections A and B below. A. Provocation in accordance with Connecticut General Statute Section 53A-19C1. Provocation is one such circumstance under which a person is not justified in using any degree of physical force in self-defense, defense of others against another, when he provokes the other person to use physical force against him. In order to provoke the use of physical force by another, it is not enough that the defendant, by his conduct, elicited the use of physical force by another. Rather, the defendant must have embarked upon such conduct with the specific intent to provoke the other into using physical force and intending to cause the other physical injury or death. The defendant must have specifically intended to provoke another into using physical force and then used force to defend himself from the ensuing use of force by the person provoked. It is important to remember that the defendant has no burden whatsoever to prove that he did not provoke James McGrath, Ryan Hines, Thomas Connery Jr., or Faison Teal with respect to their respective count into using physical force against him. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that the defendant provoked the use of physical force by James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teal with respect to their respective count against him. B, initial aggressor in accordance with Connecticut General Statutes, Section 53A 19CB. Another circumstance under which a person is not justified in using any degree of physical force in self-defense, defense of others against another, is when he is the initial aggressor in the encounter with the other person and does not both withdraw from the encounter and effectively communicate his intent to do so before using the physical force at issue in the case. Under this provision, the state can prove that the defendant was not justified in using physical force in self-defense, defense of others, by proving beyond a reasonable doubt that he was the initial aggressor in his encounter with James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teal relative to each of their respective counts, and that he neither withdrew from that encounter nor effectively communicated his intent to do so before using physical force against them. To prove that the defendant was the initial aggressor in his encounter with James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teal relative to each of their respective counts, the state need not prove that the defendant was the first person to use physical force in that encounter. The initial aggressor can be the first person who threatened to use physical force, or even the first person who appeared to threaten the imminent use of physical force under the circumstances. To prove that the defendant did not withdraw and communicate his intent to do so, the state must prove that he did not abandon the conflict in such a way that the fact of his withdrawal was perceived by James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teal relative to each of their respective counts, so that they were aware that there was no longer any danger from the original aggression. It is important to remember that the defendant has no burden whatsoever to prove that he was not the initial aggressor or that he withdrew from the encounter and communicated his intent to do so before he used physical force against James McGrath, Ryan Hines, Thomas Connery Jr., and or Faison Teal relative to each of their respective counts. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that he was the initial aggressor, did not withdraw from the encounter, and did not communicate his intent to withdraw before using physical force. Statutory disqualification to the use of deadly physical force. In addition, the state can defeat the defendant's claim of self-defense by proving a statutory disqualification to the use of deadly physical force. The statute defining self-defense, defense of others, describes certain circumstances in which a person is not justified in using deadly physical force in self-defense, defense of others against another. The exception applies only to the use of deadly force. So if you have found that the defendant used deadly physical force, you must consider this the exception of duty to retreat at A below. A, duty to retreat, Section 53A 19B1. A person is not justified in using deadly physical force upon another person if he knows that he can avoid the necessity of using such force with complete safety by retreating. This disqualification requires a defendant to retreat instead of using deadly physical force whenever two conditions are met. 1, a completely safe retreat is in fact available to him, and 2, he knows that he can avoid the necessity of using deadly physical force by making that completely safe retreat. The law stresses that self-defense, defense of others, cannot be retaliatory. It must be defensive and not punitive. The term complete safety, as used in the statute, means without any injury to the defendant whatsoever.
A person acts knowingly with respect to a circumstance described in a statute when he is aware that such circumstance exists. It is important to remember that the defendant has no burden whatsoever to prove that he could not have retreated with complete safety or that he didn't know that a safe retreat was possible before he used physical force. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that he did know that he could retreat with complete safety. In summary, if you unanimously find that the state has failed to prove beyond a reasonable doubt any of the elements of a crime to which self-defense, defense of others may apply, you shall find the defendant not guilty and not consider self-defense, defense of others. If you unanimously find all the elements of a crime to which self-defense, defense of others applies have been proven beyond a reasonable doubt, you shall then consider the defense of self-defense, defense of others. If you unanimously find that the state has proven beyond a reasonable doubt that the defendant did not act in self-defense, defense of others, or has proved one of the statutory disqualifications beyond a reasonable doubt, you must reject the defenses and find the defendant guilty. If, on the other hand, you unanimously find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defense alone, you must find the defendant not guilty, despite the fact that you may have found the elements of the crime proved beyond a reasonable doubt. Sympathy. In deciding whether the defendant is guilty or not guilty, you should not concern yourselves with the punishment or potential consequence in the event of a conviction. This is a matter exclusively within the court's function under the limitations and restrictions imposed by statute. You are to find the defendant guilty or not guilty, uninfluenced by the possible punishment or consequence that may follow a conviction. You should not allow any display of emotion by counsel during the trial to draw upon your sympathy. There is no place for sympathy in your deliberations. You should not be influenced by any sympathy for the defendant, the defendant's family, the decedent, the decedent's family, the complainants, or for any other person who might in any way be affected by your decision. Implicit bias. As I indicated earlier, your verdict must be based on the evidence introduced in court and my instructions on the law. Our system of justice depends on judges like me and jurors like you making careful, unbiased, and fair decisions. During our interactions with other people, it is not unusual for us to group or categorize people. Sometimes these categorizations involve negative or positive biases or prejudices, which may be conscious or unconscious. Such preferences or biases, whether they are conscious or unconscious, have no place in a courtroom or your deliberations, where our goal is to treat all parties equally and to arrive at a just, fair, and unbiased verdict. All people deserve fair treatment in our system of justice, regardless of their race, national origin, religion, age, disability, gender, gender identity, sexual orientation, education, income level, or any other personal characteristic. Techniques that you can use as jurors to check whether any unconscious biases are influencing you include slowing down and examining your thought processes thoroughly to identify where you may be relying on reflexive gut reactions and to consider whether you are making assumptions that have no basis in the evidence. Ask yourself whether you would view the evidence differently if the parties, witnesses, or attorneys had different personal characteristics. In sum, your task is to render a verdict based on facts drawn only from the evidence introduced in the courtroom and from the law as stated in my instructions to you, and not based on prejudice or bias or against any party or person involved in the trial. Duties upon retiring. In conclusion, I press upon you that you are duty-bound as jurors to determine the facts based on the evidence as it has been presented, to apply the law as I have outlined it, and then to render a verdict of guilty or not guilty as to each count. When you reach a verdict, it must be unanimous. That is, all 12 of you must agree on the verdict. As a check that your verdict is in fact unanimous, the clerk may ask each of you to individually announce your verdict in court. It is the duty of each juror to discuss and consider the opinions of the other jurors. Each of you takes into the jury room your individual experience and wisdom. Your task is to pull that experience and wisdom. You do that by giving your views and listening to the views of others. There must necessarily be discussion and give and take within the scope of your oath. That is the way in which a unanimous verdict is reached. Despite that, in the last analysis, it is your individual duty to make up your own mind and to decide this case based on the basis of your individual judgment and conscience. Note-taking. If you took notes during the evidence, you may use them during deliberations, and you may discuss your notes with your fellow jurors. Remember that notes are merely aids to your memory and should not be given precedence over your independent recollection of the evidence. If there is a conflict between your recollection and your notes or the notes of any other juror, it is your recollection of the evidence that must prevail. Your notes or the notes of any other juror are not evidence. You will recall my earlier definition of what constitutes evidence. Your verdict must be based exclusively on evidence presented at trial and the principles of law given to you in these final instructions. A juror who has not taken notes should rely on his or her recollection of the evidence and should not be influenced by the fact that other jurors have taken notes. Notes are only a tool and not always accurate. Do not assume that a voluminous note taker has taken notes that are necessarily more accurate than your memory. You may discuss your notes with your fellow jurors during the deliberation phase. The decision to do so is yours and yours alone. After the trial is concluded, all notes will be collected by court staff and destroyed. In closing, I remind you that you have the right to request portions of the testimony to be read back to you if you deem it essential during your deliberations. You will have all the admitted exhibits with you during deliberations. You may only deliberate when all 12 of you are present in the jury room. Inform the judicial marshal or court officer when you have reached a verdict, but do not tell him or her the verdict. You will be asked to return to the courtroom where your foreperson will announce the verdict orally in response to questions from the courtroom clerk. The rest of the panel will be asked whether they concur with the verdict. If you have any questions, please send them out as a note signed by the foreperson marked with the time, and please be as specific as possible. You will have the exhibits with you during your deliberations. We will also send in with you a computer on which you will be able to view or hear digital evidence with instructions on how to use the computer, which will be marked as a court exhibit. You will also have with you in the jury room a copy of these instructions entitled Jury Charge, which will be marked as a court exhibit. I remind you, however, that you should follow all the court's instructions and not single out some and ignore others. They are all equally important. Do not begin deliberations until you have selected one of your members to be the foreperson of the jury and you have received the jury charge, the substitute information, the device, instructions on how to access the device, and all fully admitted exhibits. So at this point in time, I am going to ask the jurors to please step out and go into the jury room for a brief moment. I do have to make some comments on the record. Do not begin your deliberations just yet, as the alternate jurors will be in that room with regular jurors. So please remain silent just for a few moments as a jury panel, and I will be bringing you right back into the courtroom. Thank you. Comments, any questions, counsel, any questions, comments, or exceptions to the court's charge?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
All right, and it's a good thing we told him just a brief moment. We'll bring the jury back in, please. Thank you.
Point out one more, Your Honor.
Thank you.
All right. Ladies and gentlemen of the jury, at this time, I am going to ask all regular jurors to please stand.
You're a regular juror, please stand. Alternate jurors, please remain seated.
Regular jurors, I'm going to direct you to the deliberations room. You're going to go into the room. You will be deliberating shortly. I will ask you to hold off until such time as you have all of the exhibits. You've selected a foreperson, you have the substitute information, and you have my jury charge as well as the device and the instructions, okay? So I would ask all regular jurors to please go into the jury room. Once you have all of those documents and the device, and you've selected a foreperson, you can begin your deliberations on this case. The alternate jurors, please just be patient with the court for just a moment. Thank you. Madam Clerk is going to state your name and ask you to stand just to be confirmed. Throughout the trial, I know it may be somewhat frustrating to hear the evidence and not participate in the actual deliberations, but you do perform a very important function by being here, and we appreciate that. Now, while it is unusual, alternate jurors are sometimes called upon to take the place of a juror during deliberations. For that reason, I am going to ask you to go back to the jury assembly room and report back to that room and remain there every day until such time as there is a verdict. The same instructions are going to apply to you as I've repeated them throughout the trial. Do not read, listen to, or watch anything about this case. Do not speak to anyone or let anyone speak to you, not even the other alternates or one of the primary jurors. Do not make any private investigations or do any research. When there is a verdict, we will bring you into the courtroom so that you can hear what the verdict is. So I apologize for this, but it has happened. So I am going to ask you to please abide by your oath. I do continue to appreciate the service that you are giving us. It is an extremely important one. The marshal is going to escort you to the jury deliberations room, and I will ask you to continue to report here daily back to the jury deliberations room. The clerk will update you throughout the day, and once there is a verdict, you'll be brought back in to hear the verdict. Thank you so much. Thank you. Okay. Counsel, at this time, I am going to ask you please to meet with Madam Clerk and make sure that all full exhibits are going to the jury and that only full exhibits are going to the jury. Please make sure that the latest substitute information is going to the jury. Also, please check the instructions for the device. Please make sure that you are okay with those instructions. I did ask you to look at the exhibit list to make sure that you were okay with the description of each exhibit. If you are, then we'll mark that and we'll have that go in as well. And then I will just state for the record that there were two things in my charge that I caught while reading the charge. I intend to make that change. I believe they were both under self-defense. Yes, they were. Under initial aggressor, B was before using physical force against, and it was them. I had to add them. And then there was also at the end, in describing statutory disqualifications, just added, and I did do it on the record, beyond a reasonable doubt. All right, so I will make those two changes, and I will submit that to the clerk as an exhibit, our final exhibit, to go into the deliberation. Was there something else?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, so then we're going to take a brief recess, and I'll come back on the bench just to confirm that you've gone through the exhibits, and I'll hear any issues, and then I'll have Madam Clerk deliver all of the exhibits and the device for deliberations. Court's going to take a 10-minute recess. Thank you.
All rise. Court's in recess. Good morning, Your Honor.
Good morning.
Morning, Your Honor.
Good morning. All right, counsel. I just want to go over the exhibits and everything that's going in to the jury. So I have asked Madam Clerk to make the exhibit list, the substitute information, the computer instructions, and the jury charge that I just handed the clerk, a court full exhibit. So those items will be going to the jury to have with them during their deliberations. Do either of you have any questions on that, or would you like to review those exhibits before they go in?
The state does not have any issue with that, Your Honor.
Defense has no issues, Your Honor.
Okay. So then, aside from those exhibits and obviously the device, have you reviewed all of the full exhibits going in to the jury for deliberations? My question is, are all full exhibits going in? Are any full exhibits not there that you are aware of?
No, we've reviewed all the exhibits, Your Honor, and we believe we've accounted for every exhibit that was submitted as a full exhibit.
Defense agrees, Your Honor.
Okay. And I just want to make sure, are there any exhibits for ID only that are going in that you noticed?
No, Your Honor.
No, Your Honor.
Okay. All right. Is there anything else that you would like to bring to the court's attention relative to the deliberations?
No, Your
Nothing
Honor.
from the state, Your Honor.
Okay. So at this point in time, Madam Clerk, just for the record, if you could please let me know in terms of full exhibits, core exhibits, what are the references and what are the identification numbers?
So court exhibit number 3, is the jury charge.
Okay, so jury charge, core exhibit 3, full. Okay.
And then number 4 is the juror laptop instructions, which is full as well.
Laptop instructions is 4, full, thank you.
And then the substitute information is full, number 5.
Number 5, full, substitute info.
And the exhibit list is number 6, full.
All right, with that then, I would ask Madam Clerk to please deliver to the jury the full exhibits, as well as the full exhibits that counsel have had the opportunity to go through. And the jury can start deliberating. It is about 2 minutes to 11. If I receive any notes, I will, of course, inform counsel. If you are planning to leave or remove yourselves from this immediate area, just please let the clerk know how to best reach you. And we'll be able to do that if we receive a note. Okay? Thank you so much. Court stands in recess.
All rise. Court's in recess.
Counsel, before the jury comes in, I just want to let everyone know that the court did receive a note from the jury. I'm going to mark that note as a court exhibit. The note reads, "We are hopelessly deadlocked, 11-1 on the charge of murder at count 1. Signed by James Stolman, jury foreperson, 12:47 p.m. My intention is to bring the jury in, give them a brief instruction to continue deliberating, and then send them back out to continue their deliberations. Counsel, do either of you wish to be heard on the note?
No, Your Honor.
No, Your Honor.
So I would ask my clerk to mark this. Thank you. And then I would ask for our jury to be brought in. All right. Welcome back, ladies and gentlemen of the jury. Counsel, please stipulate that all 12 members of our jury are present.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
Thank you. Thank you. All right, ladies and gentlemen, I did receive a note from you regarding count 1 and the fact that you are deadlocked on count 1. That has been marked as Court Exhibit 7. Look, I recognize that most of you, if not all of you, have never been through this process before. There are numerous exhibits and many days of evidence to consider. I did instruct you to consider all the evidence. By the court's estimate, at the time that we received the note, which was 12:47 p.m., you had been deliberating for just about 2 hours or less. Please remember, each of the 4 counts must be deliberated upon separately. If you would like to deliberate on counts 2, 3, and 4, and then return to count 1, that is fine. At this point, I simply suggest that you continue with your deliberations. You should review the evidence and the position of each juror to determine if any evidence has been overlooked or any juror's position misunderstood with respect to either the evidence or the law. Please continue to discuss and consider the opinions of other jurors. Kindly explain your views and listen to the views of others. Majority, please listen to what the minority has to say. Minority, please listen to what the majority has to say. Ultimately, you will make up your own mind and decide this case based on your own individual judgment and conscience. But at this time, please return to the jury room to continue on with your deliberations. Thank you. Any comments related to the court's charge to the jury?
Nothing from the state, Your Honor.
Not from the defense.
All right, court stands in recess. Thank you.
All rise, go to recess. All right, hello, hello. Can you all hear me now? I think you can. I see it jumping. Hear me yet? Let me know if you can hear me. Because I'm showing that it's feeding through finally. We're making some progress. All right, there's output. Can you hear me now? No? All right, let me just see here. Connor, showing. All right, I think I'm back now. All right, sorry about that. I had to mute because I had to have a conversation with my son, but I think we are good now. I was checking. I think there were some delays. Here we are. We're finally back. I apologize. Like I said, I had to get all this out. I didn't get a chance to do sound tests because I was like, you know what? I'm here. I'm going to jump in. I got to talk about this case because it's been on my mind, and I wanted to talk about it. All right, so let me start where I was at. First off, hello, everyone. And thank you guys for joining us. All right. Secondly, I want to remind you guys, don't read too much into this being 11-1 on one count, because the jury was under the instructions to begin deliberate, that they could only deliberate one count at a time. So I'll thank you guys. Thank you, buddy. He's in this stage where he wants to tell on himself and everything's an accident. And he's like, I went over and I touched this. And I'm like, it's okay, son. You're good. And you're probably going to maybe hear him in the background, because once he knows I'm live, he likes to be heard. But you had the judge laid out for the jury. If you remember, they deliberate each charge separately. So what that means is they have not started on 2, 3, and 4. They started on 1. So the 11-1 could very well be not guilty, and it could be guilty. I think it's very difficult to tell which side they're on in this instance, because you could have somebody very passionate on either side. Now, my perspective on this case is, I think when you listen to the defense's closing argument and you contrast it with the state's closing argument, and you look at the arguments being made in this case, self-defense cases are cases that a lot of jurors, these are the ones that jurors acquit on. And I think in this case, to me, what stands out for me is this. A lot, if you go into the comments, and I've been through my comments section quite a bit, I've tried to respond to some of them. A lot of people get hung up on, hey, he returned, he came back. But that's not what the defense said, and that's not what he testified to. What you have is a situation where a young man, shows up with his friends. And what we're to believe is again, it's really unbelievable to me, but we're to believe that this young man becomes enraged because his friend's car gets beaten up. And that the very friend whose car gets destroyed by this angry mob of teenagers, which is not hard to believe, because that's how that's how this happens when they get together, that suddenly this young man says, I'm going to go stab people to death, right? I'm just going to go on a rage and just start stabbing random people. That's clearly not what was happening here. And anyone reading it that way is just ignoring, in my opinion, reasonable logic, because what we clearly know happened here, and if you, and maybe being a father of 4 boys, 2 of which are in the teenage years, and one of which I've had to experience nothing like this, but I've experienced this lack of logic and this desire to be a man and support your friends. And, I got to stand up for my friends. That all overrides. And for them, and this is where I was at, where I said to me that, and maybe the defense attorney didn't feel there was enough value in doing this, but one thing that I know there's been a wealth of studies done on, it's number one is how, due to the lack of development in the frontal cortex of the brain, mobs of teenagers come together and they can make horrible decisions, and they become murderous. They can become killers in a mob setting. And it accelerates fast. And that's what happened in this case. They all pile out of the house. They're destroying this car. And it's not until that knife comes out that breaks that mob of that. What we needed was you can't invade the province of the jury's decision making. What you can do is you can educate the jury. And I put out a piece and a document out earlier in the trial explaining the law in Connecticut that allows. And there were 3 experts that they could have used to talk about this. Secondarily, the idea of self-defense, which you have to understand, is in the eye of the individual. It's not in your eyes. It's in his defense did a good job of reminding us. It's in the eye of the individual at that moment. So it's not as easy to. There was a football player down in Florida who shot people who came to his house, and that jury acquitted him of self-defense because it was argued to the jury, and it's very true. This is how it's viewed through that person. And in the eyes of a 16-year-old kid, self-defense is, he's got an attack on his mind. In his mind, he was being invited to this property. He was being called upon. In fact, what he was being done is he was having his manhood challenged if he didn't show up. And they were going back and forth. And it wasn't just him. It was him and a group of his friends that were accelerating each other. And then there was another group of friends that were over here accelerating each other. And they were all accelerating the situation. So this idea that you're going to say that he's the aggressor and he was not the aggressor. They were all the aggressors. So thereby, you can't put him as just the aggressor. It was both groups were equally doing this. And as a result, when he arrives, he goes down there and they get attacked by this group of kids. Now, of course, the idea here is well, anybody that's older and wiser and their brains better developed would drive the hell away and call the police. In that age group with those people, they can't do that. It's like the brain would block them from doing that because it would be looked at as a sign of weakness. And those very kids that are claiming how afraid they were, and you could never have thought of this. Who would have thought that you would have, I believe that was Tyler Rich said back to the fence. Who would have thought that somebody would run? Well, who would have thought that a gang of 30 kids is going to go out on a car, break a windshield, bust off a bumper, and spray somebody down with WD-40? Who would have thought that, Mr. Rich? Well, that's exactly what you guys were doing. And you guys could have all gone in a house, locked the door, and if these guys would have invaded the province of your house, if they would have tried to bash down the doors, they would have tried to come in, you would have absolutely been in your well rights to defend yourself. But you came out with a group of violence-hungry kids who were ready to watch fights, who were ready to record fights, who were ready to accelerate this thing. And out they come. And they do that. They attack that car. Anybody that says that they didn't retreat, not only that, to me, they go down the street. Now, I understand exactly. I can see exactly. I can see one of my sons would be the guy that would be dumb enough, like the Silva and probably Valle, who is a very popular guy, knows all these people, and would think, I'm going to walk down there, right back into the lion's den, and I'm going to try to talk to these guys. And this is why it would have been important to have a psychologist who talks about the psychology of a 16-year-old, not talking about their independent thoughts or decision-making, but the overall understanding of it and how stupid it is. And his attorney did a great job. It said, man, there was a lot of stupid going on that night. Oh, thank you, Bodie. Man, there was a lot of stupid going on that night. Because there was. But that's how 16-year-olds are. I remember my company I worked for, CEO, my company, we were at a meeting. We were at a meeting for managers, and he was talking about his sons and his kids. And he said, man, when they get to be about 15, 16 years old, man, they're stupid. Man, they don't make good decisions. And that's exactly right. That's what we saw in this case. It was a whole group of bad decisions, and a whole group of bad decisions encouraging more bad decisions. So here we go, right? He goes back down there. Now, what happens? There's one guy in the car who flips him the knife, right? Now, this is where I really am bothered, because this is where the prosecution literally, you could say, in my opinion, is twisting, turning facts that they know not to be true. And that is this. And they literally used immunity agreements and the threat of prosecution to drive a theory that allows them to get to the big M. I can't say it on YouTube. I slip it out sometimes. And this is the fact that they say the return to the car to allegedly get a knife. Well, it's pretty clear that didn't happen. He was given the knife and flipped it from Jack, right? And he goes down there because they think they're going to go down there and talk to these people. And what happens? They get converged upon by an angry mob. So from his perspective at that point, he is watching his friend. I mean, one thing that I think, to me, there was one person that should have had a doctor. The defense should have been able to call a doctor in there. And you know who it was? It was to talk about Tyler da Silva's injuries. Because the whole choice for Valle to act was based on Tyler da Silva's injuries and what he said he injured. Concussion, contusions. He was in the hospital yesterday. Or not yesterday, but the next day. And that's significant because he was getting beaten severely. He was bloody. There was one of the witnesses said he was bloody. He was unconscious. This angry mob of kids, again, this is where it's like, what would they have been willing to do? They would have been willing to kill. Why? Because we know it's happened. And there's wealth of studies. There's wealth of times that mobs have acted, angry mobs of teenagers have acted and done things, heinous things, killed people, beaten people down. And these are kids that independently would have never done it. But when it came together, they can't even explain why they did it. It just accelerated one on top of the other. The only reason why that stopped, the only reason why that did not happen, the only reason why we're not here at the trial of the brutal beatdown of a young man named Tyler da Silva, who died and was beaten unconscious and then died days later, and now all those kids are on trial, is because the knife came out. And that is the truth. And Valle, I believe, returned to the car, saw he wasn't in there, and I believe that story. I think it makes perfect sense. What doesn't make any sense is he's going to run to the car and grab a knife he doesn't even know was there. He had no idea that knife was there. He had no idea where that knife was. He had no idea what was going on. It doesn't make any sense. You know? And to me, this is where I think the attorney's going to look at it and say, well, we don't have to prove anything. We don't have a burden. And then you're getting into a burden. And then you're inviting the prosecution to call witnesses. And, it does open up a rabbit hole. But I think it would have been important context for the jury to understand back there thinking about this in the correct and proper context. And then fully understanding, because again, it hammers home the idea that this is not a decision that you make based on your own. Now you bring your own life experiences into it. But this is not about your perspective or what you think. This is about what Raul Valle believed in that moment, at that time, facing down 30 to 40 angry teenagers, watching them beat his friend. He's getting beat. He's on the ground, and he's making decisions. And to me, this is not some targeted knife attack. It really isn't. I mean, this doesn't even make any sense with the amount of people. And Jimmy McGrath, we can't say for certain what he was doing. Everyone has said now, of course, and this is the thing where when someone passes away, they become angels. And I understand that. I'm not taking away from it. It's a very tragic situation. But we also have to acknowledge the fact that there is this tendency that when somebody passes away, when someone dies, that all of a sudden they do no wrong. All of a sudden, everything they've ever done in life is great. And in this case, nobody saw him attacking. Nobody saw him involved. Yet, we know he was interested. He was asking what was going on, and he was there. And you can't rule out beyond a reasonable doubt that he wasn't involved because we don't have the footage. Now, here's the other question. Where is the footage that we know exists based on the testimony that was put in court, where there was close-up footage that never made its way into the police hands that could have answered all of those questions? And that's something that I think the defense attorney should have also arranged, because that's a big reasonable doubt that says, where is it? Why wasn't it produced? Why was the only footage produced for the jury or to the police footage that was either incriminated Valle or wasn't enough to incriminate anyone else, and left enough room that they could explain whatever they wanted to put in there, and it didn't show any key moments? So that's where I fall on this case. I think this young man should be acquitted. I think it's a tough one for jurors to acquit sometimes in cases like this, when there's young people who've died and there's other people that have stabbed, and there's a community that they have to go back and face. So it's a tough one. Now, my hope is that if this is 11-1 guilty, we have the one holdout, and they get a chance to go do this all over again, and hopefully maybe they get a chance to come back and take another bite at the apple and do a different presentation. So let's go in here now. I apologize. I wanted to go, speak to you guys a little bit. Now we're going to I'm going to moderate a little bit and put up some comments. So let's see what you guys are feeling right now. I'm going to go back a little bit. We're going to go back a minute or two. So your points will be great for appeal if he needs to go there. Parents supplied the alcohol. So let's talk about that. Yes, they did. And this is something that, listen, I have told both of my boys who are older, and my younger boys the same thing. There will never be a party at my house where I'm supplying alcohol for minors, ever. And that's not going to happen. And nor will I co-sign them to go to a party where someone else is supplying alcohol. I understand that's, and they say, oh yeah, well, Dad, it's going to happen. Well, it might happen, and it might happen under my nose, but I'm never going to knowingly do that, because I understand in today's day and age, I'm taking responsibility for that. And I will end up in jail, or I will end up charged. And look, there was a trial that just happened down in Florida where there was I think it was a teacher or something that went down there, and she was supplying alcohol and drinking alcohol, and she went through a whole trial. She was convicted of it. And so this is not something that you can mess around with, but it's also something that I think that got lost in this case, that you can see that for some reason, well, it's not for some reason. Let's put it down to what it was. They're punishing Raul Valle because he did not cooperate, because he relied on his right to remain silent, and as a result, other voices rose up around him. That, again, let's be clear on this, okay? This was a scenario where, listen, and let's be clear, if Valle was the one to be, if his group had gotten there first and they were the ones that cut the deals, they could have very well potentially had a scenario where these kids were facing potentially felony murder charges for, and there I said the word, for the death of James McGrath, because they were, if it was viewed as them as the aggressors and they're doing a beatdown and they're killing someone and someone acts in self-defense to defend against this angry mob, and they were committing a felony, which stomping to the head, beating someone to a concussion, felony assault, defending against that. So these kids had a lot to lose, not to mention that they had potential. Again, the rich family had the potential to get charged for providing alcohol to minors. Numerous assault charges that could have been filed for the angry gang beatdown that was going on. So there was a lot of incentive for them to twist this story, and that's exactly what happened. And this is the danger. This is why people should absolutely be distrustful of prosecutors who make deals. Everyone should be held accountable equally, and they can come into court and tell their story if they want to, and if they don't, boom. But so let's see here. Supplied, yes. Jody says yes. Parents should be on trial too. Absolutely, they should be on trial, and they should be, absolutely held accountable for this. An example should be made. Listen, if we're going to hold a parent accountable, as the Crumleys were, for not securing a firearm, if you're not securing alcohol that leads to someone's death, why don't we have the manslaughter to that? Right? That was reckless. And they recklessly did not protect the alcohol. They green lit because somebody had to buy the alcohol. Somebody had to buy the alcohol that led to a drunken showdown that led to the death of another young man. If we're going to go down that path, now I'm not in support of that because I think that's really good. But I'm saying in this day and age, at a very minimum, they should face charges for providing the alcohol. The prosecutor kept saying you don't bring a knife, but Valle didn't bring the knife. It was given to him by exactly. He didn't bring this knife to a fist fight. He put a knife in his pocket that his friend threw him. Listen, it's a 3-inch pocket knife. Who in the world would ever think that a 3-inch pocket knife is something you're going to use that's going to, be considered to be this? It's not like he was bringing a 6-inch or 10-inch stiletto knife or switchblade or something like that. It was a pocket knife that was thrown to him by his friend and said, if you need it. Right? And sure enough, he did need it. He was beaten to the ground. His friend was being beaten. And guess who stayed in the car? The coward who stayed in the car, who could have come out and helped, who nobody has yet held accountable, Jack. Right? Maybe if he comes out and helps, no knife has to come out at all. Maybe if he doesn't throw the knife to Raul Valle. But this guy should absolutely not be walking the streets free if you're going to hold Raul, because it's not right. It's not right that this kid gets to walk free and have the rest of his life. And he's the one who brought the knife. He's the one who drives back. He's the driver. I mean, we're talking about Raul Valle, who he was driven back by Jack. And all these kids get a free walk because they're going to get to say that they're going to turn on their friend. Not to mention, my God, as I showed my son in this case, I said, listen, this is a cautionary tale about your friends. And it's his football coach was going on about that. We had a big discussion telling them about, listen, a lot, because there's been a lot of problems and things with people doing stupid stuff for friends or fights occurring, and says, listen, these kids that you think are your friends today, as a football coach, I sat there and listened to the whole thing. He said, listen, today I had a whole group of friends when I was in high school. Now I got 3 core friends left. So all these people you think are your friends that are encouraging you to do all this funny stuff, that are doing things for laughs or doing this or doing that or fighting because they think you're tough, none of these people mean anything to you 20 years from now. And they don't care where your life goes. And there's no greater example than these kids who've been together and friends since they were 5 years old. And these guys traded this young man's life for their own and are okay sending their best friend down the river for life. And they're willing to twist and change their story. Nothing more despicable, nothing more disgusting than seeing that happen. And I'm sure, I can't imagine how that young man felt, and he'll have trust issues for the rest of his life, depending on where he's going for the rest of his life. Did they know who was taking those other videos? They probably didn't want to get involved. Oh, they saw them. Yes, they questioned them. They absolutely did. And what the kids said is that they were unfortunately deleted on Snapchat. And again, as anybody knows about Snapchat, they probably did delete them on Snapchat, and they weren't able to resurface them, and things like that can happen, and they're gone. So they're gone forever. Or if they aren't, then they're around, but they didn't try hard to go get them. Sandra Martin says 100. Bodie says jurors are usually looking for a reason to say guilty, in my opinion. I think there is a tendency. Yes, I agree with that. There is a tendency in jurors to assume that because you were charged, and see, this runs antithetical to the idea of what our justice system is founded on, and that is that you are not to assume that. You are to assume, and remember, Raul Valle, regardless of whether you like him or not, or you agree with him or not, he comes into that courtroom. The moment he walks in, he is presumed innocent. Okay, and every defendant is. All the most unlikable ones, even Brian Koberger, until he pled guilty, was presumed innocent. That's why they get to have their street clothes on if they're being held without bond or they can't make bond. They're presumed innocent, and that is the most important fundamental thing that should be respected because it's important, and it's also important that when a jury begins its analysis of the case, that they begin from that perspective, and that's very difficult for jurors because many are going to begin from the perspective, the opposite end, and they're going to be going, okay, all right, he's guilty, and this is what proves it, as opposed to saying, okay, let's take a look at it and let's start going down here. What are doubts? What reasonable doubts do we have? And again, it's only one reasonable doubt about to one element of the crime. They can prove if there's 3 elements to a crime and they prove 2 beyond a reasonable doubt, and 1 they have a doubt on. And a doubt is just something that makes you pause. It says, can you pause and without would you lie at night? You lay your head down on your pillow, or are you still thinking about it and you're going, man, I can't, I think, but I don't know. Is there a pause? And if there is, you got to come back not guilty. There's no 2 bits around it. Let's just go down here and see what we got. Let's see, we're going to go down here. We're just kind of going in, seeing parents will be sued after this trial. Let's go here. Bodie says the parents will be sued after this trial, at least civilly. Oh, absolutely. I do believe there's already active lawsuits potentially going on. I'm pretty certain I heard that. But yes, there absolutely will be, and the homeowners will be sued too. The homeowners insurance can be sued in this instance because it happened on the property on the front lawn. So the McGraths can absolutely sue. And that's who they should go after, is sue for this happening, especially because the parents were negligent in allowing alcohol, allowing a party, allowing unsupervised. Remember, listen, you don't get to have 40, 16-year-olds at your house unsupervised, right? You still have a duty to supervise your children. And certainly if you're going to have 40 of them. And when somebody goes over, when somebody goes over or kids come over to your house, you have a duty to ensure. And not only that, and you can't say, well, I was away, I didn't know. Well, you left your kid alone. Okay. And they're still a child even until they turn 18. And by child, I mean, you're responsible for them and their actions. And that's what parents fail to understand. And that's why the parent that says, oh, yeah, it's fine, I'll let my kid drink. That's great. You do that, right? And then when somebody drives away from your house who's drunk and plows into someone else, you're going to have culpability in that issue. And you can be sued, and you can be brought upon criminally for providing alcohol to a minor. And there's all sorts of potential possibilities that can happen out of that. And that's a problem. But it's a problem that many, 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 many people don't consider. Because they look at it, and yes, I understand, 15, 16, 17, 18 years old, they're older, they seem more responsible than they are, but at the end of the day, their decision-making is still not there. They still have not lived long enough to make the right decisions, and they still need guidance, and they still need supervision. And had a parent been present, they could have come out and said, everybody get in this house, and you boys get the heck out of here, and we're exchange information. And again, this should have gone a lot different. Nobody needs to walk down back to that house and start talking about the damage done to the car. Jack Schneider should have gone home, and he should have talked to his parents, and his parents should have gone out and talked to the Riches, and they should have said, listen, this happened to your house last night, and we need to know who's going to take care of this, and we're going to file a claim against your homeowner's insurance because this happened here, or else you guys are going to pay for the repairs, or however they want to do it. But it should have been handled in a totally different manner than them going back and getting into a physical altercation. But again, remember, They didn't throw the first punch when they came back. And the state has to frame it like, oh, they were defending their property. They weren't defending their property. Okay, they were wanting, like, it was like, they're back. Okay, we're coming out. Well, good. Then retreat. Go back into your house. Find out what it is that they're coming back for. They weren't coming back with weapons. They didn't come in and attack anybody. They weren't trying to drive the car up the driveway. They pulled up and they got surrounded and they had their property damaged. And they had their bumper ripped off their car and their windshield cracked. And then they had, like I said, Raul Valle was sprayed down with WD-40. They're throwing stuff. I mean, it was nonsense, but it was nonsense until somebody got hurt. So the idea that you're going to say, oh, the only aggressor here and the guy who's just propelling this whole thing is this young man is ridiculous. It's ridiculous. And it should be absolutely sent back out. Let's see what we have here. Well, Tyler Rich's parents, as you heard, his dad was out. They don't know. They didn't say where he was. I don't know what he was doing. Sounded like he wasn't doing something he's supposed to be, because they kind of framed it as your dad was elsewhere. Mom was on a trip. Dad was wherever dads go, I guess, when the wife's out of town and they're out and about. And Tyler was home. Now, Tyler was, I believe, 18 at the time. So, Tyler himself understands that he had some pretty grave responsibility in this, because he's the one there who could face a lot of charges, because he's the one that was allowing the minors to come in and drink alcohol at his house, and he was the adult that was supervising. So that's the part that's lost on people. Tyler Rich was the supervising adult, and that's why he said, I thought I had it under control. And Tyler Rich, who's clearly a very respected individual in all of their circles, had a lot to lose, because he was a supervising adult. And everyone wants to say, where were the parents? Well, the parents didn't have any obligation to supervise Tyler Rich. Tyler Rich, his parents were all adults. Tyler Rich was a supervising adult. He was 18 at the time that this happened. Thereby, his parents had no responsibility to the situation, nor were they, because he was an adult. So under the law, he was the supervising adult that was home, and he was the one that was authorizing and allowing the kids to drink. And that is why this whole group, who were all subservient to Tyler Rich, because he was the big popular guy, as you know. I mean, everybody came up there, Tyler Rich parties, man. We all went to Tyler Rich parties. We all know who Tyler Rich is. They're the big cat. They're the big dog in town. They're the one that everybody wants to be. They're the one everyone wants to be around. And in this case, well, guess what? He was acting that way, and everybody was over it. And he walked out, and he's the one beating. Now, listen, remember, Tyler Rich is hitting a minor. He punched a minor in the face. He's 18 years old. He should have been charged for the punches. Now, he's going to say, well, I'm defending my house. No, you weren't. You're punching a minor in the face, setting off something that leads to Jimmy McGrath dying, leads to others getting stabbed. So this is about the cover-up to protect Tyler Rich. And basically what the social circle said was, who's more important, Raul Valle or Tyler Rich? And everyone in that trial circled Tyler Rich and themselves and their own self-interest. Because that's where this led. Tyler Rich, the supervising adult, would have been facing lots of charges. Now, I don't know who Tyler Rich's parents are. I don't know anything about them. What I do know is they must be important people, because the police obviously found it that they were going to protect him, and that everyone else decided to protect him and said, okay. And then they went and put pressure on the two boys that were with him and said, well, we're gonna finish this off and finish off the protection of Tyler Rich by working out immunity agreements that requires the friends who were in the car to say that this young man was in this rage, who just wants to go out and start knifing people to death like Freddy Krueger in a horror film. And he just goes in there and is just like, you know what? I'm so mad at you guys. I'm going to stab you up. No, that makes no freaking sense. And anybody who processes it that way is just being biased. It's just looking at an independent thing and acting on emotions and hearing part of the case, not the whole case. Not sitting down and thinking it through. And certainly not applying the law of self-defense when you look at it through the eyes of this young man who's facing down 15 to 20 drunk, potentially high on other substances, teens who are just out for blood, who are out for Instagram, Snapchat moments, who are out to beat the hell out of somebody and embarrass these people, embarrass these kids, and show them that they're man, that they're the man, that they're the man. They're showing the consequences. You pull up, you come out. I mean, these are the kids. Listen, remember, they're inviting the St. Joe's kids into the chat. It's not a St. Joe's chat that they're inviting the Shelton kids in. They're getting invited in so they can chat and plan this out. And then, Raul Valle is like, oh, yeah, let's invite him out here to the school and do that, and that'll be funny. That does not show a man with intent. Bodie, question. Did the parents get probation? That's what a chatter is saying. I haven't heard that, and it seems like I would have heard that. I do believe one party did potentially get probation, but I think it was at the other house, because that one was definitive, because Tyler Rich's parents would not have been responsible for that necessarily, although they would be considered the homeowners. Tyler Rich is an adult that would be there. Okay. Is a adult that would be present. I'll do further research on that, but I do believe it was the first house that faced the charges. And let me do a quick dive on that. And give me a moment here. I'm going to step away for just one moment, guys. All right, never mind. I thought my son needed me. He was just laying something down. All right, let's see here. Let me go in here and do some research. And the other thing too, guys, I want you to understand it too. I was in a jury that was we were 10-2 guilty when I was on the jury. 10-2 guilty when we went back. And we flipped. So just 11 on one side doesn't mean that this jury's done deliberating. It means they were trying to get out of it, I guess, and they were a little confused. But there it was. Yeah, it was the other house. Yes, that's what I thought. Paul and Susanna Leifer. Because again, the Riches parents were not responsible because Tyler Rich was responsible. This is what you guys don't understand. That Tyler Rich is the key here, man. Tyler Rich is the key. It's his life. He is the guy. He's the big dog in this equation. He's the one they're all protecting because he was the guy he's the head of the social pyramid. He's at the top of the pyramid, and they're protecting him because it was his butt that was on the line. That he's the one that was going to get the charges. He's the one that's punching a minor. He's the one that's providing the alcohol. He's the one that should be in handcuffs, sitting there being charged, and he was not charged. He hasn't been charged. He hasn't been held responsible because they wanted his testimony. Because they had to frame it as, again, the state couldn't charge him if they're going to say Raul Valle was the aggressor. All right, so let me go in here. But anyways, listen, Bodie, I agree with you. And I told my sons, stupid. Stupid. All right, so here's the deal, guys. Here's the lowdown. Paul and Susanna Leifer were charged with permitting minors to possess alcohol. Additionally, there was charged with second-degree reckless endangerment as she reportedly engaged with some of the underage attendees at the gathering. So Susanna was charged with reckless endangerment because she engaged actually drinking with these kids at that party. Current status, the lifers were released on a promise to appear, and there hasn't been any updates publicly. Their case appears to be still pending or possibly diverted as first-time offenders. Yes, there's been lawsuits. Obviously, Jack Snyder and Tyler Da Silva were charged, but that's it. That's it. And what about? Let's see here. Let me look up. And the Riches, nothing. And Tyler Rich, who's a witness, can't be charged. The party host, because he could not be charged because of the fact that because they had to the state is portraying him as de-escalating the situation. So in their theory of the case, he's attempting to de-escalate, and he's the de-escalator, and they didn't try to charge him, nor did they charge him with the fact that people were providing alcohol for minors there, because again, he's a key person that they didn't want to have charges with, because then he wouldn't cooperate and testify, because without him, they don't have a case. Without him, well, these other kids don't cooperate. He's the leader. And his parents had no criminal liability because they were not, again, he was the adult that was at home. He was the presiding adult. So they did not have any connection to him and or his decisions because he was 18. So, that's what it is. Well, Ed Zapp, guess what, buddy? You get an all-expense vacation here now, courtesy of justice. Give me a moment. Oh, maybe somebody else already did. Oh, good. Bodie did. Thank you. We kick out the people that are not here for the right reasons. And you get a little all-expense vacation right away, and you can head on out to other aspects of YouTube. There's plenty more where you can go watch. And a lot of videos I put up that don't have the host involved, so watch away. Anyways, M. Scola says, okay, I posted it in the other group, Paul and Susanna Lyford. Thank you, M. Scola. I appreciate everybody that comes in. Well, Hannah B., we don't know. Listen, don't be so quick to judge that this is a holdout for not guilty and that it's not for guilty, because remember, there's going to be people, in a case like this, there's a young man that passed away, and they may be saying, there's no way in the world am I going to sit here and am I going to be able to stomach the idea that this kid walks away. In fact, what this tells you is, and here's the psychology that tells you this is probably not guilty, right? What did the judge, why would you, okay, 2 hours in, why would you be coming out saying you're deadlocked on one? There are 3 separate guilty potential possibilities. So you would just move right on down and go, okay, let's move the man to, right? If it's a one holdout and that person's not guilty, you start moving them down and say, okay, what do you think here? Well, all right, let's move down to man 2. If it's 12 not guilty and 1 guilty, now you've got a problem, because you've got, okay, there's no room to move. The not guilties have all found self-defense. There's one person that says it's not self-defense. How do we solve that? We really can't. So they come back out to the judge. So in my opinion, I think this speaks more to the potential of a not guilty because of how quick they walked out and said we're deadlocked. Because if this was 11 guilties of first M, and then you've got 1 holdout, you would say, okay, let's work around this. Let's see what we can do here. And that person says, well, self-defense. Well, is it self-defense? Let's talk about this. Could we get down to M? Could we get down to man 1? Could we get down to man 2? I mean, there's a lot of movement around there. Man reckless. Talk to us. And I don't think they would have jumped right out and said, okay, we're deadlocked. But I think when you've got 12 people that are saying it's self-defense, you're not going to move, or 11 people that are self-defense and 1 person guilty. And that person's like, listen, I don't think it's self-defense, and they're sitting there, and then you got 11 people say it is. There isn't really movement. There's not movement down. That one person's not going to move 11 people down to man 1 or move 11 people down to man 2, because these people are saying, I think it's relatively simple. So, and that's why they would run right back out. So, in my opinion, I think these people were back there, and I think they were moved like anybody else listening to the defense attorney. His defense attorney's closing made a lot of sense. And when you listen to it, and you really listen to it and compare it to what the state was saying, the state almost feel, it doesn't even really, it's like you can almost see he feels almost uncomfortable up there trying to make some of the arguments he's making because they don't really align with the evidence, and they don't align with what your eyes see in the tapes. And the fact that these kids, that these kids. Hey, Zap, why don't you, instead of, getting upset at someone speaking to you intelligently about things, why don't you share with us your thoughts, please? Go ahead and put your thought in there as to why you think this, and go ahead, throw it out, because I know I can anticipate almost all of your answers. Please throw out some of your wisdom into the chat as to why you believe that this is and how and why this was. I mean, you believe these kids, clearly, I guess. So you think that they're telling the truth. You think that this was some craze. This kid, this guy, stands out and just decides overnight to become a crazed killer. So go ahead, tell us, please. Please. Enlighten us, sir. Because I think that you're clearly biased, and I think that when you're looking at this case, you're acting on the emotion of someone dying, and you think, well, someone died, so therefore someone has to be held accountable. It doesn't quite work that way. And I heard that in my chat, in my comments. Someone died. So, no, that doesn't occur equally, right? There's all reasons for it. But if someone dies in defense of another, or someone dies defending themselves, or someone dies because it was in defense of themselves, well, guess what? You don't necessarily punish someone for that. Well, Ed Zap, make us have a clue. You can give a thumbs down all day you want. I really don't care. I want to hear from you. I don't think clearly. I can see you can type. I can see you can put things in the chat. So come on, give me something. I mean, I want to hear it from you because I have an idea what your argument's going to be, and it's going to be absolutely easy to dismiss because you're going to show yourself real quick, which is why you're going to hide behind comments like that. You're going to hide behind insults, or you're going to hide behind shut up, host. Yeah, because you don't want to hear something that's legally sound and makes sense with the law, and you want to hear the emotional take that you have on the case, which says someone died, therefore it's got to be this, or well, he stabbed somebody. No, it's not that simple. You need to look at the entirety of the situation, and you need to not just assume just because the prosecution charges. But I'll tell you what, a lot of people take that approach. Oh, the prosecution charge, somebody's being prosecuted. And you know what? I've seen it time and time again. People with that mindset until someone close to them gets charged, until somebody sits in that seat and they're wrongfully accused, or they're accused of something and it's being made more than what it is, or people are twisting and turning, or somebody's using immunity agreements and non-prosecution agreements to try to reframe things. And Skull, absolutely. Listen, I have said that to me. Listen, the ridiculous offer. This case should have been resolved with a man-to plea, with assault two, and this kid should have been doing no more than 10 years in prison, and he should have been probably. I think they could have settled this with a 6 to 8 year sentence. But if they do 10, he only serves 60%. So therefore, or I think it might be 65%. So he would have done no more than 6.5 years. And I understand he's going to look at this and go, I don't want to serve any time. But 40 years for this and nobody else gets anything. And I think that they shouldn't, and then they should have not worked. No one else should have got immunity. People should have gotten deals, right? Deals with time that reflects exactly what their contribution was. And the idea, now here's the thing. Anybody out there, and I challenge anyone out there to think that De Silva, and particularly Jack Schneider, and no, you can time him out. I don't care. Time him out. I hope you did. Are you talking about what's his name? Ed? Yeah, time him out. Listen, if he's going to come in here, he ain't coming in here right, and that's fine. Time him out. He could come back in a minute and share with me. But he wasn't taking the. I can see what he was saying. He was not trying to put anything positive in here. So time him out. Time away. We don't need stuff like that. This is This is here for serious people. I'll listen to any serious perspective, and it doesn't have to agree with me at all. And I will give it consideration and weight and respect, but I will not. I will not. And I have no problem with any of my mods. You time out anybody comes in here disrespecting anyone in the chat, me, or just being disrespectful in general. That's not what we're here for. And he can come back in when he wants, when his timeout is over, and he can share with us something, or he can get timed out again. So you're all good, Bodie. I appreciate you. You do what you need to do there. You make sure, I trust all my mods and to make good decisions, and I've not yet disagreed with one necessarily. So let's see here. Hannah B says, all you have to do is imagine a 300-pound person stomping on them and know that, exactly. I mean, listen, this is crazy, man. It's crazy the way that the state has prosecuted this case. And, it's really upsetting. It's upsetting to me because I think the idea that we're going to lock this man up or this young man up for what amounts to pretty much the most of his productive years. And I understand Jimmy McGrath lost his life, and that is devastating. And there's nothing you can do to his first parents. If it was my son, I'd be inconsolable. And they deserve to have civil suits, and they deserve to sue people, and they deserve to get remunerated, and they deserve to absolutely. But what they should also be doing is advocating that says we need to make sure that it becomes clear out of this case that unsupervised parties with alcohol, that accountability must be present, and they should be mad. They should be angry that Tyler Rich is walking away with this with nothing but the ability to lie, reframe. I mean, Tyler Rich was an aggressor in this. Tyler Rich led the band out there to the band of angry teenagers who were looking to his leadership. And I've been around Tyler Rich. I know what happened that night in the sense of I can picture it in my mind. And his leadership was lacking that night. And he was not leading them away from a fight. He was leading them towards a fight. And they were doing what they thought needed to be done to impress him and everybody else there that they thought that they respected. And this thing accelerated. And there were less, and people, it was going and going and going. And that group think that group mentality kicked in, and it accelerated fast, and it blew out of control. And that is where Tyler Rich is absolutely 100% being honest when he says I lost control. But he did. He thought he had control, but he lost control. Because what he doesn't understand is when you get a bunch of drunk, angry teenagers who are all encouraging each other, it's a combustible deal that just exploded. And it exploded in that front yard where somebody was going to die that night or be or be tremendously hurt. Remember, does anyone remember the Texas football player who was like knocked unconscious and brain dead down in that they came out and had an angry group of football players that came out and beat the shit out of this kid in the street? Does anyone remember that? And all those football players got charged. This is no different. That's where this would have gone, because it would have been Tyler Da Silva who would have been unconscious, facing either life-altering injuries, or he'd have been dead. And his friend pulled out a knife, and it is tragic what happened after that. But if he doesn't pull that knife out, then Tyler Da Silva isn't even able to remember what happened, and he isn't testifying because he won't even remember, because he's having brain damage and brain injuries. And that's the truth. So Taz says, with the whole immunity thing, they're basically just saying what they all did was fine. No consequences for it. That is exactly correct, Taz. And that is the problem I have with the immunity agreement. So I was on a point, and then we got distracted with the gentleman there. My point I was making was this. The prosecution excused Schneider and Da Silva, who are two people that I think are equally as guilty as anything Raul is alleged to have done, or Raul alleged to have done. And then they chose to not charge Rich, they chose to not charge Faison, they chose to not charge any other people that were throwing blows and punching people. When they chose to do that, that means that same punishment is okay for Raul Valle. He doesn't get any more than they do. He doesn't get any more responsibility than they do. He wasn't any more involved than they were. He was part of a group who went out of control. And the question is, and I like that from his attorney, who said, why is he different? Why do we separate him from that group? And that is a question everyone should be asking. Why was this young man? I want you to look at this young man, and I want you to ask yourself, what's so different about Raul Valle? And what's so different from the kid you saw on that witness stand and this young man? And you just come to your own conclusions. Why was it so easy to throw that young man down the river? Why was he disposable and everyone else wasn't? And the answer is he shouldn't be any more disposable. In fact, how they were treated is how he should be treated. And the jury now, and this is why I would, his attorney, if I'm attorney, I'm saying that exactly there, which he kind of said it. But it's like, the great thing is this: you are the equalizer. The jury is the equalizer. They have the ability to even this up. They have the ability to stop the state from acting in an unequal and unfair way. M. Scholl says that they're in Connecticut, 20 minutes from Shelton. Okay, so M. Scholl, do share with us. What is the community sentiment? What's this jury looking at when they go back in there if they were to acquit this young kid? How long would they deliberate today? Thank you so much for this coverage. It's important. Thank you, Melis, Montana Yoga, and Home. I appreciate that. I think they will deliberate. I think they deliberate if it's similar to what I've seen in previous cases. There was a case in December. I'm trying to remember his name. He was a guy that stabbed his wife in a camper. They cut out at 4:30 every day, 4:30, 5 o'clock every day, unless they requested to stay extra. My assumption is they will leave at 4:30 today, and they will come back tomorrow. They did the same thing in like Massachusetts. These northern states seem to have, business day deliberations, and they're not trying to keep the jury because, listen, it's funny. Southern courts love to keep a jury in and hang it in there all day long and lock them up in the room until they come up with a verdict, which makes them feel like they can never go home. Whereas the northern juries are kind of more businesslike, and they really don't want to invade the province of the jury room and say, we don't want the jury to feel pressured. So they're very careful. I think they're going to probably be dismissed here very shortly, unless they come back to the judge and say, we would like to stay for another hour or so and do some more work. But we'll see. I don't think we're going to get a verdict today. I think that I don't know. Maybe we will, but and then again, they might come back out because I do believe the judge gave the Allen charge. So if they were to come back out at 4:30 and say we're still hung and we're not moving and we don't see anything else, then the judge is going to have no choice but to dismiss the jury. Now the question becomes, of course, they're going to have to also come back out and look at the assault charges. So again, the judge already told them you can set aside count 1 and move to counts 2, 3, and 4. So that will give us a little more perspective as they move in. If they're hung on everything, I mean, it's kind of a complicated way of deliberating, but that's how it is. M. School says he sprayed W240 in value. Absolutely did. Exactly. And Ryan pulled his shirt over his head. Listen, there was so much going on that night, man, that these kids that are walking away scot-free, it's ridiculous. And again, I go back to the Nicolay Mew case, okay, where those kids were culpable and what happened. And it's really a case to look at because that was a case where the group provoked this thing to go way out of control. And then Nicolay Mew, of course, there's some differences there because Nicolay Mew gets up and he starts stabbing people. But the reality is they were sicking on him in that case. And then he acted, the jury got it right in that case, I think, in the sense, except for the fact that they probably didn't know how severe the sentence was going to be, that it was essentially going to be a life sentence for anything he got convicted of. So let's see here. Unbothered says, why did they surround, or let's start with Lally. He says, why did they surround the car? Exactly. Why did they surround the car? They surrounded the car because they were attacking them, because they were going out to enact mob violence because it accelerated. As you know, they didn't start out that way. It accelerated. And the more group that got out there, somebody hits the bumper, somebody's standing on the bumper, now somebody breaks the windshield, and it just got crazier. And that's how it goes. And that's how these things accelerate. Unbothered, F60 says, this seems like the predictable outcome of the social conditioning by parents of boys will be boys. It normalizes horrific acts and breeds monsters with no empathy. Well, I think it's more than that, though, because Unbothered, you have to recognize that there were females involved in that group of 30 to 40 kids that were out there doing this. I think what this tells us is that it's group violence, and it's the ability to, and it's just teens coming together. Listen, there are a group of teen girls that go out and do things. Look at the Slender Man girls. There's a group of girls that will go out and do heinous acts to themselves. There was a West Virginia case where a couple of girls killed another little girl. So when they get together, I think it's more of as opposed to saying it's boys or it's girls, and then you're alienating your group. I think we have to look at it and say this is teenagers. This is a group of that we're putting too much responsibility on our kids. On top of that, we're underestimating what social media, YouTube, all these factors that come in and all of this and how they're processing all of this. And then when they go down there and it's supplementing life experience. So when they do things, remember, we all go back to our life experience bank when we deal with things. And all they've seen are violent things, violent video games, violent acts, violent YouTube videos, violence, and it's all about manning up. It's all about who's toughest. It's all about this. And then they get into a situation where they're drinking, and now they're untethered from their conscious thought processes, and they're just acting. And then they're acting to impress each other. It just doesn't stop until it accelerates to such a point that something tragic happens, and then everybody pulls back, right? And that's where we're at in this, I think. So I think it's really talking about re-educating parents and everyone on the idea of, okay, how do we deal with things, and how do we manage allowing big groups of kids to come together, and making sure that we don't have these unmanaged situations, that we can't have parties. I mean, it's going to happen sometimes, but we have to make it so that the parents pay attention. So if parents leave town, listen, you have the ability to put cameras up or whatever you need to do, right? If you're going to leave your teens alone, you need to know what's going on in your house. In this case, Tyler Rich is a young kid. His prefrontal cortex isn't developed. He's just as young as them. I mean, he's 18 on paper, but that doesn't mean jack. He's out there doing the same stupid shit as they are, just because you're 18. Now, from a legal perspective, he's responsible. So I think we all have to evaluate that, and we have to look at the science that's coming in behind this. If Valle's found guilty, the other kids will feel totally absolutely they will, just like the other kids in the Mew case felt justified for what they did, and that was something that they accelerated, and it became a group thing. And remember the famous line in the Mew case, for the culture, and they beat this man down, and then he stabs him. And of course, a lot of his actions and behaviors and things that happened after that said, well, he's stabbing these young kids. Well, these young kids became a rabid, murderous group. And again, the defense of Nicolay Mew did not put on the stuff I'm talking about, which is valid. It's valid in understanding how these things develop. It's valid in understanding how dangerous a rabid group of teenagers drinking under the influence of substances can be. Caught Kaysen says not guilty. M. Scholes says, I think Valle had his shirt up on his face trying to clean the WD. Absolutely, probably did. Yeah, well, listen, you've got to remember, everything should be questioned about how it's being portrayed, because there's probably an innocent explanation when you're looking at it in there of what's happening. And Valle may not even remember specific things, because he may just remember, I was wiping it out of my face, I was trying to do this, and other kids are now taking that. Because remember, what they were tasked with was, you must portray Valle as the aggressor. So anything you can remember, anything you can come up with, anything you can remember that he did that favors that, make sure that you and your friends don't end up with charges, or someone important to you doesn't end up with a charge. And then it becomes a social equation. Who's more important? And kids make that decision all the time. Bodie says, Steve, question. Do you think there is a racial component to this? I'm not going to say that necessarily. I'm not going to jump to that. I'll let you draw your own conclusions. I think we all let our eyes do the looking here, and we just look and say, we have to deduce on our own. What is the difference? And his attorney threw that out there, and I think it stands. What makes him different? I'm not going to say that that is it. I think we have to look and say, why is everyone comfortable with this? Why is he the bad guy? Why is he the one we're all comfortable or supposed to be comfortable hating? Why is he the one that gets labeled the crazed maniac? And to me, I'm uncomfortable with him being labeled that way because I don't think he was. I think he was just a kid in a group in a bad situation, and the prosecutors needed someone to blame. And he was the one also, too, I believe, who chose to remain silent, who chose to assert his rights. And the system loves to punish people like that. They love to make it clear that if you can remember, when we walk away from this, you come talk to us, we give you an immunity deal. You walk away from us and you assert your rights, well, you're sitting there getting tried. You're sitting there spending your resources against the resources of the state to try to get yourself off of a charge. That's fine. Stay silent. That's fine. Assert your constitutional rights at your own expense, at the expense and financial devastation of your parents or yourself or whoever is going to back your defense. And that should be something that disturbs everyone because there shouldn't be a consequence like that for asserting your rights. It should be respected by everyone. It shouldn't be looked down upon. That is exactly how it's supposed to be. There's a reason why we have a right to remain silent. Listen, no private citizen should ever feel comfortable going up against a trained detective police officer who has spent hours in seminars learning how to trip you up and learning how to possibly even get a false confession out of you. Okay? We all must remember that happens. We all must remember cases like the Ty Tucker case where you had somebody who comes in and immediately starts implanting information. We know there are cases after case after case after case of the Reed technique that was used on people incorrectly and got confessions that later on were proven through DNA evidence. And that's one of the reasons why we learned how bad and devastating the Reed technique was, is because DNA came along and started to disprove some of these confessions and showed that they couldn't happen the way they were. So any idea or any attack on the idea that you shouldn't remain silent or that you should come talk to police officers should be rebuked hugely, and it should be rebuked by a jury of a prosecutor who tries to frame a reward or create a reward system or create a punishment for someone who asserted their rights. Because in this case, that's what he did. He never talked to the police, and you heard that. In fact, there was a situation when he was testifying. The prosecutor jumped up and said, "Wait, we get to now bring that up. You know, we weren't going to get to talk about that, but now we get to talk about the fact that he decided not to give a statement. He decided not to talk about what happened. You know, he decided to just tell a story now. While everybody else is telling us their story then. Well, that's it. But then Scholes says, I think it depends. Honestly, it depends on who's on the jury in Connecticut. Connecticut is unpredictable. Yep, I think you're right. Probably it is. And I think it's going to matter about the makeup of that jury. Older or younger, which we don't know, unfortunately. The girls buy into it like eternalized misogyny, unbothered F60 says. Bodie says yes to racial. Or Bodie, yes to racial. That's and School believes there's a racial component. Caucasian says, hit the like button. Thanks for the good coverage. Thank you, Caucasian. I really appreciate that. And please do hit the like button. It does help these videos get out. And our goal is to try to educate. And my goal in this is to do what again, as some of you may or may not know my background or why I'm even here doing all of this, and started with my dad who passed away, who was a very well-renowned criminal defense attorney in the state of West Virginia, who has many victories for self-defense under his belt. And that's where some of these things got imparted in me. And we were telling his story and wanting to cover the criminal justice system, and the whole justice as a process is a famous thing he would get asked. The question, how can you defend people? How can you defend criminals? And he would say, justice is a process. And the process is about making sure that every individual's rights are respected in the process. And that is what's important. It's not about the outcome. I'm not here to get somebody off. I'm not here to make sure they're found guilty or not guilty. I'm here to ensure that every single right that they are allowed to, that they get access to, that they fully understand, and that they're able to ask the questions, assert the rights. And any time, the only evaluation of the justice process should be that evaluation. And any time someone's rights aren't respected, anytime someone's rights aren't asserted, or that they're not made aware of them, that is a failure of the process. And that is why justice is a process. We are here to watch and make sure that this is getting to these things. And in this case, we can say that, yes, this has not been a fair process to Raul Valle. That we have seen the process ignore people with immunity agreements. We have seen the attack on the right to remain silent and somebody be essentially penalized because they did that, because they didn't speak with the police right afterwards when the police wanted them to, and they went and put the whole case on their back. When we know, if you look at this case fairly, this does not belong on the back of that young man. It does not, and it's wrong. M. Scholes says the kid who got immunity are YT. There's your answer. Yeah. Well, I'm not sure what YT means. Maybe I'm missing. I see that and say YouTube, but I don't think that. Young teenagers, is that maybe what you're saying? Bad Barney said, no bullet says mob mentality. Same as the police, really nice kind of guy until calling for backup. Then you see the real mentality. Absolutely. Absolutely. You see it in police officers. That's a great point, Bad Barney. Police officers have the same thing happen. One night you got a cop that acts like you see that. Think about the cop that you see running on. Watch body cam footage, and you see the cop comes in. I mean, look at the situation with George Floyd. Derek Chauvin comes on the scene, and the whole thing changes. And next thing you know, you're dealing with all of that mess. And before that, they're trying to get the guy in the car, they're trying to work with him, and yeah, he's being uncooperative, but it's like, why come on and be an asshole? Like, we're expecting the police to come on and figure out a way around this, and they should be trained in how to deal with this. And if they're not, pull them off the street, get them trained, and get them back out there. They're not here to accelerate a situation. They're here to decelerate. They're here to protect. They're here to protect us. And the question is, if we all fear police officers, how can police do their jobs? In college, I took a criminal justice course with the chief of police, who I knew because of my dad, and he and I did a presentation together in the class, and it was quite interesting because he was promoting something called, and he had just changed, and I found out about it because of my dad, and he and I were talking about it. So we took it on in the class, community-oriented policing. And he had changed the local police department, which had a really bad reputation. And he was talking about it in there. And he did a presentation. This is the presentation we were talking about, which was community-oriented policing, which is the idea that you have cops walk beats, but it's the idea that police can't police without trust from the community, because that's who they have to go to solve crimes. So if you go and alienate the community and you go and alienate those people, it hurts your ability to work, and that you should be looked at as a part of the community, not someone that's feared by the community. And this gentleman did a great job, and he retired. He's no longer chief of police now. And that police department did a 180 in terms of how they used to have a lot of problems with beating people and violating rights. And there was just all sorts of problems, and there was a lot of fear. So you got pulled over by them, and they changed that. And those cops, to still today, you still see them walking beats. You see the bicycle patrol out. And the whole point of that was what he promoted was you go into the storekeeper, you go in and you talk to somebody, you introduce yourself and say, I'm Officer such and such. How you doing? And when you see a member of the community, you say hi to them and you treat them with respect and you shock them. You don't make them talk to you, and you don't demand that they show you some, oh, how you doing, officer? I mean, now our sheriff's department, listen, there's been many stories that somebody glanced at a sheriff's deputy in their car and got pulled over and said, you don't look at a police officer. Well, what the hell's that? I watched a sheriff deputy in the middle of the thing. Somebody was pulled in, and this lady was kind of a little timid and scared, and he stops his car and just starts screaming at her and telling her, get the hell out of there. You know what? And she said, it's a red light. Well, you know what? I'll pull you over for being in the middle of the intersection. And it's like, what are you doing, dude? Like, this lady clearly looked fearful. Does that do anything good for the relationship with the community? No, it doesn't. Now, I kind of went off on a tangent there, but the whole point is, yes, even in police, when you get a group, when you go from one single person to a whole group, it's amazing how it can build on each other. Yes, they should. In fact, an extreme version of that, Bodie, was in the Davis stabbings trial, where they literally got to control it, and it took 3.5 weeks for them to conclude their deliberations, where they only deliberated 9 days out of 3.5 weeks. And finally, the judge called them in, and turned out they found them not guilty of second degree, and then they were hung on everything else. But what a mess! I mean, what a mess that turned into. But yeah, I do believe they should be able to have some limited control, not quite the control that judge gave. Groups cannot have a conscience; only individuals can. Very strong and valid point, Hannah B. Very strong and valid point. You're correct. The conscious leaves the group. That is exactly correct. CO2 heart, not sure what that is. Steve, is the blue bracelet? Is the blue bracelet for a cause? Yes, it is. It's for diabetes awareness. In fact, I got this. My son is a type 1 diabetic. I have actually had people when I've been online, they've misinterpreted what my cause was for having this. Some got upset because they thought it was for causes but no, this is for my son. And I've worked from the day right after he got diagnosed, which was in 2020. The school nurse gave this to us for diabetes awareness. And I have wore it every day. And the funny thing is, this thing never leaves me. I have lost it. I have taken it off and it finds its way back to me and I put it right back on. But I wear it for my son. So that's why I'm wearing that. And that is for him. And he, like I said, he is he was diagnosed in 2020, and like I said, it's a journey. It's a journey with that. M School says punks. Unbothered F60 says, I think masculinity needs to be redefined. Well, I mean, that's a definite debate out there. I don't know that we need to redefine anything. I think we need to we need to evaluate our understanding, because there's a lot more science behind how we can understand things now. So I think when we start talking about redefining, we have to start talking about it not as a problem necessarily. We have to look at it as, let's understand it better, because I think we misunderstand it. And I think what ends up happening is we parent, our parenting ends up, or the way we're parenting young men, I think ends up inadvertently causing problems for them and how they approach the world. I think we have to look at the examples that we're setting, but I think there's a way to do it without having to alienate somebody and say, well, you're wrong for this. It's just, no, we need to understand it better. We need to understand the way you're thinking and the way the thoughts are, and we need to understand how we communicate, because it's really communication deficits. And when you're the masculine man, the man's man that believes the world runs a certain particular way, there's a way you have to communicate with that individual, and we have to decode that and figure out how do we communicate. And then what we start to realize is, once we start to communicate with everybody, we realize it's communication deficits that separate us all. We understand that we all kind of have the same idea. We all have the same place we want to go. It's just we all have a different understanding. We all hear things a little different, and we all interpret things a little different. So I think it's more of a communication deficit. Bodie, what is YT? Laugh out loud. I don't know. I'm wondering myself. Was that you, Bodie, you said that? I'm not sure who said it. Oh, no, that was M. Scully. Yeah, I don't know. We'll see. Maybe the answer's here. Oh, my God. OMG typing girl fights. There's a lot of it. Oops, let me put that up so you all see what I'm saying. Raul was put in a situation that most people can't understand because of his age. That's exactly correct. And it's that mentality. See, like I said, he was defending himself. He was being attacked in a way that, like, for us adults, no longer hits the same way. Although there are some adults that might. But for most adults that are at a certain stage in their life, they're not going to understand how some of the things that were being said, why that would lead you to show up. But also, it means he was invited. Hold on.
All right, so the time is just about 4:45, nearing the end of the day, so I'm going to go ahead and release the jurors for the evening. So ask the jury to be brought in. Thank you. Counsel, please stipulate to which one of our jurors.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
Thank you. So, ladies and gentlemen, jury, it is a little bit after 5:45. At this point in time, I am going to send you home for the evening. I'm going to bring you back tomorrow morning for continued deliberations. All of the rules of juror conduct are in place. They're all important. However, before you go home for the evening, I want to remind you of a few things. You must continue to avoid all communications to and from anyone regarding this case, except communications with your fellow jurors only when all 12 of you are present here in our jury deliberations room. Avoid any media and social media platforms while you are not here, and obviously while you are here, where you may find information about this case. Do not visit any locations mentioned, look up any statutes mentioned, or conduct any experiment or research, either individually or as a group. We are going to reconvene tomorrow morning. I will bring you in first thing in the morning and provide you with additional instruction, and then we'll go on from there, okay? So we'll see you back tomorrow for continued deliberations. Please take your role as jurors, which I know that you are doing. Please take that role responsibly. Again, there is a lot of media coverage relative to this particular case. Have a good evening. We'll see you back tomorrow. Thank you. Court stands adjourned.
All right, guys. So there you go. Court is adjourned. So we're not going to get a verdict today. I guess what that means is they went back and rolled their sleeves up. And again, like I told you, I experienced a jury that was 10-2 when we first went back. And essentially it flipped to the other side. So it means nothing in terms of them coming out and going 11-1. It doesn't mean that means that they're close to anything. They can flip right back over, and especially with the judge telling them to dig into potential lessers. We'll see what happens here. I don't know. I feel like it's concerning at this point because, if I don't know, we'll see where it comes. I think they're going to come. I don't think they're going to come at the top. I think they're going to come with a mixed verdict. If this is guilty, I think they will come in, as I have said from the beginning. If you have one person that is staunchly not guilty, I think they will lay their sword down and everyone else will follow at second degree, man. And then I think the rest then there will be debate between first and second degree assault, and each one has to be taken on as their own independent actions. All right, so let's see where we're at here. Let me jump down here to still deadlocked. Linda Law says, I think his attorney is very good at. I think so too. I liked his attorney. Like a lot of people didn't like his attorney. I thought his attorney did a good job. I was critical of some things, that I thought he should have done. Like I said, I think that he should have gone extra. But again, every attorney has their own idea. They know and they think to themselves. And of course, they also have a resource issue. I'm sure these experts cost money, and the state. You're not going to necessarily get the court to allow that. And maybe they asked for these things. And the state may have filed a motion in limine not to allow it to come in and precluded it. And maybe there was a ruling that the judge wasn't going to allow it. All that's possible because it's not like Florida where we have access to the full record. Thank you, Bad Barney. I appreciate that. Also, thank you, Bodie. I did see your comment up here about my dad being proud. I appreciate that. Very much. And Miss Missouri Penny, this makes me so sad. I feel so sorry for this young man. I do too. I think this is a sad case, and I think it's a sad case. It's a tough case, man. It's a tough case. It's every parent's nightmare. It's every kid's nightmare, because like in that moment, everything seems so like it needed to be resolved. And then the next day, I'm sure the weight of what happened and what occurred was just like, what the hell was I doing? Why did I do this? But it looks like we have another case starting. I just saw college student strangling trial. So be on the lookout for that. We will be covering that. Starts tomorrow. So be on the lookout for the case report. If you're a member, you're going to get the members only case report. Be aware of that, guys. If you're a member, if you're a Justice Watcher member, you always get an exclusive case report that gives you a full breakdown on the background of a case, everything that goes on, all legal issues, everything you can. We dig in. We are working on that right now. On top of that, right now we have the Justice Fusion reports, which are connected with every single video that goes out. Dig into those. Those are free for everyone right now. If you're a subscriber or you're watching the video, you get it. And then we're going to have some other things that we're trying to dig in there or get for members. Where we're going to be trying to get deeper reports and things. And we're going to do some members only lives as well as I get on the ground here. So I do apologize. I know some of you may be thinking to yourself, you're members and you're getting neglected and you're not getting the attention you deserve. We're going to get it there. Just so you guys understand what's going on, what I keep referencing, I reference it sometimes in the stuff. I'll kind of touch on it here. My 2024 was rough. My dad died at the beginning of that year. That was very tough. 2025 has been unbelievable. We've had so much death. I have a lot of older family members, but my wife's mother unexpectedly dies. We had a surgery we had to deal with my now 10-month-old. Everything's good with him with that. But that took us out of town. But really the big one was my wife's mother got sick. Now we always knew my wife's father is terminal cancer, and we were thinking he was going to go. Well, now my wife's mother went, and now he's kind of now alone, and we're having to manage him from afar and travel a lot, and we're in and out of town, and there's been a lot going on with him. And then he fell and broke his hip, and he's now in a rehab center for his hip, and we're just dealing with a lot of stuff, and we're trying to manage his affairs, and we're all doing a lot of stuff. So I'm moving in and out and doing a lot of remote stuff because I have this whole thing. I can run the whole studio from anywhere, right? As long as you get a good internet connection. Well, guess what? They don't have a very good internet connection where they live. So I have to go when we're up there. I'm moving around to the McDonald's and the coffee shops. Thank you, Miss Missouri Penny. Welcome, and very much appreciate you becoming a member. And like I said, there'll be lots of, you're also going to get access to, since you're a member, I'll tell you, every case, be on the lookout. And please, guys, go to the community and go to your members page. It's there that you're going to see all the drops and all access to the links. But every case also gets a members toolkit, where instead of you having to go back to the individual videos, you're going to see all the fusion reports, all the transcripts, all the special reports that I will do throughout a trial, and members only reports will all be in one place. So you can go in and enjoy it and pull up your case and really dig into the facts of the case and the analysis of the case that we're doing. As you can tell, I like writing. I like to do stuff like that. I like to be able to produce things. That was something I always did with my dad, and and he imparted in me, and I was always his paralegal whenever he had things he was representing himself on. So I have a background in it, and it gives me an outlet. So I like to be able to produce things and do things. So check it out. It's a great resource. You get the case background right there, and it gives you just a broader, greater understanding. And when we do our members only dive-ins, we're going to be using those things. We're going to be talking about those things. Yes, thank you. It's like I said, it's very difficult, and it's a lot. It's a lot. My wife is a nurse, so it's been a lot on her too, because she works in a psych unit, and boy, let me tell you, it's just been crazy there. But she's been going through a lot, struggling with the loss of her mom, whom she was very, very close with, and then moving right on to her dad. So she's like work, road, and I'm trying to go with her and help her out and take all the stuff off, try to keep as much off her plate as I can so she can move around and do what she needs to do and get done. And it's just, and then we got 4 kids. So I'm dealing with the kids on the ground here. So it's a lot, but this is, like I said, we're trying to manage the channel and keep this thing going, because like I said, it's something that, and she's going to be on at some point. She wants to come on. She has, like I said, she has some valuable insights as well, because she literally deals with some of these people that we see in her role as a psych nurse. Now, she can't get into specifics or anything, but she has a lot of good insight. Thank you, Hannah B. I appreciate that. And M. Scola, any updates? What updates are you asking for? Let me know, and I will give you an update. But I appreciate that. Thank you, Hannah. I think it's, like I said, I'd like to have that stuff in front of me, and I like to be able to produce it and have it and put it together. And it helps me understand the case better, and just get into the facts and the background of the case. So to me, it's very valuable, and I hope you guys see value in it as well. And then check out the descriptions too. The descriptions, we try to put a lot into the descriptions to help guide things. Even if you've already watched it, the no breaks is a great place. If you're catching up on a day or you just want to find out what happened, we try to make that be an overall overview of the day. So you go into the no breaks, you can watch it quickly, hopefully, or as quick as it is without the breaks in. And then you move into greater analysis where we're taking the segments of court and breaking it down and getting into the legal issues. And, you can stop at the description or you can click the link inside the description or the pinned comment and get right to the Justice Fusion report and understand things like case law, strategy, what's happening, what sections of the law are being argued or what's come up or what objections came in. And again, add your insights. And then on top of that, we try to also do, again, if we put it all together, eventually we'll get there, but trying to also then take it and bring little highlights of key points and key moments, and then eventually get back to shorts, which I like to do little short moments. Eventually we'll get it all together. But that's the experience I want you guys to have. So you're able to go in and just see this case and feel this case and understand this case and get your own perspective. And then also have a discussion with me. Leave comments. One thing I haven't done, I'm not the greatest YouTuber in the world, but I know I have a lot of comments out there. One day I'm going to do a live that's just going to sit down with your all's comments. Thank you, Taz. I appreciate that. That reiterates my desire to do it, because sometimes I'm sitting there like my wife is all like, I carry a laptop with me at all times. I'm working 24/7. And it's therapeutic in a way, because I used to talk to my dad about the law 24/7 and be involved with him and everything he was involved with. And now I just do this. And my wife is like, but we're on the road a lot and I'm sitting there. She doesn't like my driving. I make her car sick. So if we're driving around, and we just finally got a minivan because of how big our family is now. So we're like, there I am working away at every opportunity I can and trying to get this stuff out and trying to get things out as timely as I can. And then you hear the little ones in the back, and they're, taking care of them and getting them where they need to be at. So anyways, guys, I just want to throw those personal things in before I got off here, explain some things, but we're getting there, and we're going to be there, and we're going to start doing more lives and Justice Watch live. My podcast that I had been doing, it was supposed to be like every day, but I've done 29 episodes. I've still got another 30 I want to put together and make it a special one and come in and just talk to you guys about all the cases we've been covering and whatever it is you guys want to talk about. So let me know. We'll do that. And then also my good friend out there who, Jody on the defense rests. I feel bad. I haven't been able to meet to get with her, but we will absolutely be coming back together at some point, as long as she'll have me and she's not upset with me, because we haven't been able to do it. We didn't get to do any of our plans for Karen Reed that we were going to do. And if you haven't checked out her channel, get over there. She's over in Australia. And she comes from a nursing background similar to my wife, but she's got great insights, great take, really creative, does really good stuff. I watch her videos when I can, and she's a great graphics person. So check it out. She likes to cover older cases and stuff. She'll cover current cases. She does a really good job. Really entertaining, really cool person. And thank you, Taz. I appreciate you becoming a member, very much so. So thank you very much. So anyways, that is the state of the union here as it is for justice as a process. So hopefully you'll be seeing more of me. Those of you that have been around for a while may know that the purpose of this daily live is for me to be popping in on breaks and stuff. I have these, that's what I normally like to do. I've just been remote a lot. And right now I'm looking over at my other computer. I have a war room set up here. I got my other one here. I got to go over and stop. So I appreciate all of you too when you tell me my lives have stopped and things that I've got to get over to. So, just hopping around doing a lot. Well, I appreciate you, Hannah B. I know you're one of the ones that's been around for a long time. And again, I value every one of you. I value you, Hannah B., bringing in your perspective. We haven't always agreed on everything, but I like that. I don't always want to agree with everybody. And I appreciate everybody. So share your perspective. You will always be able to share what you need to here. Do it respectfully and make sure, but we're not going to ever allow attacks on anybody for sharing an opinion, and I invite all opinions. I think it makes us all better when we hear all different opinions. So, and that's what I miss right now. And I'm glad being able to come on and talk to you guys today because that's been fun. But I got to jump off here because tonight we have Vacation Bible School for my older kid. He's going to be my 2 older kids are running that. I have to get one of them up there because they're running it at their grandma's Vacation Bible School. So I have to jump off here and go on the road again and get that taken care of. But I appreciate all of you guys. Be on the lookout. We'll be covering, like I said, the college student trial. We've got the wife trial over there in, I believe it's Iowa. And that's an interesting case, although I think she appears to be guilty, but it looks like the defense is going to try to put the blame on the boyfriend. But what I think is extremely incriminating is the Snapchats that have come out that shows that she was up, she was talking, and he tells her, don't forget the casings. Well, what casings would you be talking about when your husband's about to get shot in an hour? Anyways, if you haven't watched it, jump on over there. We'll be putting up we've got no breaks editions up for days 1 and 2. Days 3, which is today, will be coming today. Wait a minute. No, we're on Tuesday. Sorry. Day 3 is coming. I don't think it's up yet. And day 4 will come too. Thank you, Taz. Thank you, Hannah B. Thank you, all of you. And I will hopefully see you tomorrow for the verdict, because I think we're going to get a verdict tomorrow, but I might be wrong. But we'll see. And I'll see you guys in the college student trial and the other trial that we're running. And I'll see you in the comments too. Thank you. And Bodie, thank you. I really appreciate you, and I really do appreciate the time and thoughtfulness you take in modding and everything. So don't worry, about that. You're all my mods. You will always be supported, and I appreciate everybody because I know when you're taking an action, it's to the betterment of the channel. So I appreciate that, and it's protecting us. So always know that. And sometimes, if there's ever any serious situation, we'll communicate somewhere off of this, and we'll get it settled. But never had that happen yet. Knock on wood. All right, guys. Till we talk next time, let justice prevail. And thank you, Bodie. I appreciate that. I'll put that comment up. One last thing. I like that you can think in complex ways and don't have agenda. Well, thank you, Bodie. Thank you. I appreciate that you seeing it that way, because that's important, because that's how I it's how I feel I am, and I'm glad it's coming across at least to you. So very much appreciate it. All right, guys, I will talk to you guys soon. And until then, let justice prevail, and I will see you soon. And keep your notifications on.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm, new paradigm. United and free. United and free. United and free.